267 amendments, 3 hours, and not 1 minute of debate on the vast majority of them. That is how Ireland passed the most significant reform of its asylum laws in the history of the state. The bill went through the Dáil on the 15th of April 2026, with the clock running and the Minister for Justice already preparing for the court cases he said publicly would follow. And now the woman in Áras an Uachtaráin has until Wednesday evening to decide whether to sign that bill into law, or send it to the Supreme Court and potentially collapse the entire thing before the 12th of June deadline that Brussels is not going to move. Here's the part nobody is talking about. The question being debated at official level is whether the International Protection Bill 2026 is constitutional. But the deeper question, the one that does not appear in any press release, is how a 380-page piece of legislation that touches the rights of some of the most vulnerable people in Ireland ended up being signed, sealed, and delivered with the lights barely on in the chamber. That is what this video is actually about. 3 things to hold in your mind as we go. First, what was inside those amendments that were never read out, and why does it matter who was in the room when that decision was made? Second, what actually happens to Ireland, legally, financially, politically, if the president refers this bill and the Supreme Court strikes it down with the June clock already ticking? And third, is this bill genuinely about bringing Irish asylum law into line with Europe, or is it about something else entirely, something more politically convenient? Before we go any further, quick one. Drop the city or county you are watching from in the comments below and tell me how much time you have right now. Are you on a lunch break with 15 minutes, or are you in for the full run? I want to know the geography of the people watching this one in particular, because this story will land differently depending on where you sit. Drop it below. Now, back to the gates of Áras an Uachtaráin. President Catherine Connolly is not a president who moves quickly. She took office in November 2025, and in the 6 months since, she had not once convened the Council of State under Article 26 of the Constitution. Until Monday, the 20th of April. The meeting began at 3 in the afternoon. It concluded just before 7 in the evening. 4 hours. Described afterward by sources close to government as intense. The Áras issued a brief statement. The president would consider the council's views and decide before Wednesday evening whether to sign the bill or refer it to the Supreme Court for a judgment on constitutionality. The government's position was stated clearly by Taoiseach Micheál Martin, who attended the meeting alongside Taoiseach Simon Harris, Chief Justice Donal O'Donnell, and Attorney General Rossa Fanning. The Taoiseach said he was satisfied the bill was constitutional, well-balanced, and consistent with the European Union Migration and Asylum Pact obligations. The Attorney General had confirmed it. The bill was sound. That is one version of events, and that version is accurate. It is also incomplete. Here is who else was in the room, on the record, before that Monday meeting even took place. The Irish Human Rights and Equality Commission, the state's own statutory human rights body, had issued a formal statement saying significant human rights concerns remained in the final text. The United Nations High Commissioner for Refugees had put a specific warning on the table. Children should not be detained for immigration-related reasons, under any framing, including the bill's last resort provision, allowing detention of minors for up to 12 hours. The Ombudsman for Children had previously expressed concern about the same clause. The Irish Refugee Council, alongside civil society organizations including Doris and NASC, had used the phrase, "Ireland is on a dangerous path," moving away from its international human rights commitments. None of those organizations are fringe voices. Most of them are funded, at least in part, by the Irish state. And this is precisely the detail that changes everything. The Irish Human Rights and Equality Commission is not a lobby group. It is a statutory body established by law in 2014, with a formal mandate to assess legislation for human rights compliance. When that body says a bill passed by the Oireachtas contains overly broad and questionable powers of detention, no legal advice or representation at the first stage of the process, and restrictions on family reunification that obstruct families separated by war and conflict, it is not offering an opinion. It is performing a legal function. And the government passed the bill anyway, which is technically permitted, which is technically the question the president is now sitting with. Before we get into the mechanics of what happens next, and those mechanics matter enormously, let us pull back and look at where this bill actually came from, because the origin of this legislation explains the urgency that drove it through the chamber at speed. The European Union Migration and Asylum Pact is a package of regulations agreed at EU level in May 2024. Ireland is not automatically bound by EU migration law. The state has an opt-in mechanism that requires a formal decision to participate in each measure. The government formally opted into 7 components of the pact on the 31st of July 2024. From that point, the clock started. And the deadline on that clock is the 12th of June 2026, the date by which the pact must be enacted and operational across all participating member states. Ireland knew this date for nearly 2 years before the bill passed. The legislation was published in January 2026. It went through the Seanad, came back to the Dáil, and on the 15th of April 2026, 58 days before the EU deadline, it was passed by 86 votes to 62 after that 3-hour final debate. 267 Seanad amendments were tabled for consideration. The chamber processed them in one session. Most passed without discussion. And here is where this picture gets wider than Ireland. Move from Leinster House to Brussels, and the picture is this. Ireland is one of the very few EU member states that voluntarily opted into the pact, and is genuinely attempting to meet the June deadline in full. Only 14 of 27 member states had submitted their national implementation plans by the December 2025 deadline. Hungary and the Netherlands sought opt-outs in September 2024. Poland's Prime Minister told Commission President Ursula von der Leyen in February 2025 that Poland would not implement the pact. In March 2026, just weeks before Ireland was finalizing this legislation, the European Policy Centre's migration program concluded the new system would be unable to handle mass displacement events. In other words, Ireland is doing the homework while most of the class has either skipped the assignment or is copying from someone else's notes. Dublin is at the front of the room, hand up, bill drafted, deadline respected. And the bill has a human rights problem that the state's own statutory body put in writing. That is the shape of the relationship right now. Everything we have just covered is the surface. The real story starts here, in the gap between what was debated and what was passed. The Irish Human Rights and Equality Commission documented the legislative process with unusual precision. During committee stage in February, 8 hours of debate covered approximately 14 of around 300 amendments. On the 25th of February, the Dáil guillotined proceedings after Amendment 22, following 4 hours of discussion. The Commission's statement used the phrase, "no meaningful engagement" with the amendments. Among the provisions that passed without debate were proposals aimed at preventing the unlawful detention of children, ensuring that invasive medical examinations to determine a child's age were conducted by appropriately qualified medical professionals, and strengthening oversight of the border procedure's independence requirements. The bill that landed on the president's desk was 380 pages long. Standard track, first instance decisions are to be made within 6 months, with appeals resolved within a further 3 months. The International Protection Office delivered over 20,200 first instance decisions in 2025, a 44% increase on the 14,100 decisions of 2024. The government's argument for speed is not made up. The backlog is real. The system under the previous legislation was not working. The mechanism is slightly more complex than the headlines suggest, so it is worth walking through it carefully. Under the existing International Protection Act of 2015, Ireland's asylum system operated largely outside the EU's shared framework. The new bill replaces the 2015 Act entirely. It is not an amendment, it is a replacement. The Eurodac system, the shared EU biometric database for asylum applicants, will now record every person who arrives and claims protection in Ireland. The Asylum and Migration Management Regulation, which replaces the Dublin III regulation, means the first EU country a person enters is not merely responsible for their claim. The applicant is now legally obligated to apply there. That is a stricter version of the existing rule. And critically, applications submitted before 11 in the evening on the 11th of June 2026 will continue to be processed under the old system, which means once that clock hits midnight, two parallel legal frameworks operate simultaneously, the old one and the new one, for a transition period that nobody has clearly defined the end of. If this kind of breakdown, the mechanics behind the headlines, the numbers behind the announcements, is what has been missing from your feed, you know what to do. Now, back to the numbers. Here is the single most consequential number in this story, and it is not one that has appeared in many headlines. Under Article 26 of the Irish Constitution, legislation has been referred to the Supreme Court by a president exactly 16 times in 88 years. On 9 of those occasions, the legislation was found constitutional. On 7 of those occasions, it was not. 7 out of 16. That is not a rubber stamp. When a bill is referred and found unconstitutional, it falls. The government must restart the legislative process. Not amend, restart. The 12th of June is 52 days away from today. There is no contingency legislation. There is no fallback act that would let Ireland meet the EU Pact deadline in the event of a Supreme Court referral. If the court strikes the bill down, even one significant provision, the entire thing falls, and Ireland arrives at the 12th of June with the old 2015 Act still in force, and an EU infringement risk added on top. The Minister for Justice, Jim O'Callaghan, has already said publicly that the legislation will end up in the courts because international protection is, in his words, a very litigious area. He is not wrong about that. Labour's justice spokesman Alan Kelly described it as bad legislation and predicted an army of lawyers. The minister acknowledged new legislation draws legal challenge. He said it, out loud, in the chamber. Now, that is all still abstract. Here is what it actually means for the people who live inside this system. For an asylum seeker who arrives in Ireland from the 12th of June onward, the new framework means a screening process immediately on arrival. Biometric data, security and identity checks, vulnerability assessment, health check. Within 6 months, a first instance decision. Within a further 3 months, if appealed, a final determination. Faster than the current system, which in practice has run to years. For successful applicants, protection is granted sooner. For those whose applications are refused, removal is expected to follow more quickly. Those processing timelines are the government's headline argument for the bill, and on those narrow terms, the argument is coherent. The current system is not working. Cases take too long. The International Protection Accommodation Service is expensive. The backlog generates legal uncertainty for people waiting and costs the Exchequer significant resources every year. But the bill also contains a provision that allows children to be detained in defined last resort circumstances for up to 12 hours. Not overnight, not indefinitely, 12 hours, in a system that the Ombudsman for Children and the United Nations High Commissioner for Refugees both said should not permit child detention for immigration purposes at all. And it contains no right to legal advice or representation at the first instance screening stage, the stage at which a person is allocated into the processing procedure. Which track you are on at that moment shapes the speed and character of your entire case. And you arrive at that fork without a lawyer. The Irish Human Rights and Equality Commission stated in precise terms that the bill does not provide for access to legal advice and representation at the first stage. That is not a minor procedural note. That is the moment when the system decides what kind of case you are, and you face it alone, which is technically what was passed, which is technically the law that is now sitting on the president's desk. There is a version of this story told in Leinster House about a government that faced a real backlog, accepted a European obligation, drafted complex legislation under severe time pressure, and got it over the line. And there is the version visible in the Irish Human Rights and Equality Commission statement, in the United Nations High Commissioner for Refugees warning, in the 4-hour Council of State meeting described as intense by people who were there. They are not entirely incompatible versions, but they are not the same version. What the president is weighing before Wednesday evening is not a political question. It is a constitutional one. Her 7 appointees to the Council of State include, among others, academics with backgrounds in human rights and constitutional law. The meeting lasted 4 hours. It was not a formality. Former President Michael D. Higgins convened the Council of State 4 times in 14 years under Article 26. He referred legislation to the Supreme Court once, the Judicial Appointments Commission Bill in 2023. The court found it constitutional. He had also convened the council in 2015 over an earlier international protection bill. That one was similarly rushed, similarly guillotined, and ultimately chose to sign rather than refer. President Connolly is 6 months into the role. This is her first Article 26 convening. Whatever she decides before Wednesday night, it will define how the rest of her presidency approaches the question of when the constitutional guardian speaks. Here is the ticking clock version of what Wednesday actually looks like. If she signs, the bill becomes law. The EU deadline is met. The parallel system goes live on the 12th of June. The legal challenges that the Minister for Justice has already pre-acknowledged begin arriving in the courts. Those cases will take months or years. Specific provisions may be struck down in post-enactment litigation. But Ireland is inside the pact, and the machinery starts running. If she refers, the Supreme Court must decide. The court will work quickly under Article 26. This is not ordinary litigation. But the 12th of June does not pause for constitutional proceedings. Ireland would arrive at the pact deadline in legal limbo, with the old system still operative and Brussels watching. There is no precedent in Irish constitutional history for what happens to an EU deadline when Article 26 is invoked, because this has never happened before. This is the part that connects to a much bigger structural question, one that goes well beyond this particular bill and well beyond immigration policy. Ireland has signed up to a growing number of EU obligations that require domestic legislation to be enacted by fixed calendar dates. The Migration and Asylum Pact is one. There are others in the pipeline, on digital regulation, on energy, on financial supervision. Each of those requires the Oireachtas to pass legislation that is consistent with both EU requirements and the Irish Constitution. When those two sets of obligations pull in different directions, when the EU deadline says yes and the Constitution says wait, the political incentive is to move fast and deal with the legal consequences later. That is the system that produced this bill. It is not incompetence. It is the design of the pressure. The Council of State meeting of the 20th of April 2026 was not just about the International Protection Bill. It was about whether a constitutional check on that design still functions when the political calendar is tight. President Connolly's decision before Wednesday evening is a small window. After that, the door begins to close, not just on this bill, but on the question of whether the pace of European integration can be reconciled with the pace of domestic constitutional scrutiny. The question is not going away after Wednesday. It will be back with the next deadline and the next tightly guillotined bill. Watch Wednesday evening. Watch the statement from Áras an Uachtaráin, and watch what the government says in the first 24 hours after, because the reaction to her decision will tell you more about where this is heading than the decision itself. This is the Irish Strategic Narrator. Stay close.